If you own a home and you're over 55, I need you to listen very carefully for the next 30 seconds, because what I'm about to tell you could save your family from a financial nightmare that plays out in probate courts across this country every single day. Most seniors I talk to believe their will is enough to protect their house. They think because they wrote it down and signed it, their kids will simply get the property without any drama. That belief is not just wrong. It is dangerously wrong. And the worst part is you won't be around to fix it. Your family will be the ones standing in a courtroom, spending thousands of dollars and losing months of their lives trying to untangle something you could have solved with one simple legal tool. Today we are talking about why putting your house in a trust just got smarter than ever before. And by the end of this video, you will understand exactly what a trust does, why recent changes in the law make it even more valuable right now, and the critical mistakes people make when they put this off for too long. Let me start by telling you about a woman named Patricia. Patricia was a retired school teacher from Ohio. She owned her home free and clear. She had a will that stated very plainly that her house should go to her 2 daughters equally. Patricia passed away peacefully at the age of 81, and her daughters assumed everything would be handled smoothly. 6 months later, they were still waiting. The house sat empty, while the probate court process dragged on. Attorney fees piled up. The daughters had to pay property taxes, utilities, and insurance out of their own pockets, while the legal system did what it does, which is move very, very slowly. By the time everything was settled, they had spent over $14,000 in legal fees and court costs, and the whole process created tension between the 2 sisters that took years to heal. All of this was completely avoidable. Patricia loved her daughters deeply. She just didn't know what she didn't know. This is the reality of probate, and I want you to understand it clearly because too many people use that word without really explaining what it means for you. Probate is the court-supervised process of distributing a person's assets after they die. When you have a will, that will must be validated by a probate court before any property can be transferred to your heirs. The court gets involved in everything. They verify the will is legitimate. They appoint an executor. They inventory your assets. They notify creditors. They oversee the payment of debts. They approve the final distribution. Every single step requires paperwork, attorney involvement, and time. For a house, probate can easily take 6 months to over a year, depending on which state you live in and how complicated your situation is. During that entire time, your family has no control over the property. They cannot sell it. They cannot refinance it. They cannot make major decisions about it without court approval. And here is what really stings. Probate is completely public. Anyone can walk into the courthouse and see exactly what you owned, what it was worth, and who got it. There is no privacy for your family whatsoever. Now let me tell you what happens when you put your house in a trust instead. A trust is a legal arrangement where you transfer ownership of your property into the name of the trust while you are still alive. You still live in the house. You still control the house. You can sell it, refinance it, or change your mind entirely. Nothing about your daily life changes, but from a legal standpoint, the house is now owned by the trust, not by you personally. When you pass away, there is no court process needed to transfer the property. The person you named as your successor trustee simply steps in and follows the instructions you left in the trust document. The house goes directly to your beneficiaries without probate, without court fees, and without months of waiting. This process can happen in a matter of weeks instead of a year. Your family saves thousands of dollars, and everything remains private. Nobody outside your family ever needs to know what you owned or who inherited it. Now you might be thinking this sounds like something wealthy people do. That used to be the common perception, and the legal industry did a poor job of explaining otherwise for many decades. But the truth is, a trust makes sense for almost anyone who owns a home and wants to make things simple for their family. Think about it this way. If your house is worth $300,000, probate costs in many states could easily run between 3 and 5% of the home's value when you factor in attorney fees, court fees, appraisals, and other expenses. That is $9,000 to $15,000 your family could lose simply because the proper paperwork was not in place. That money could have gone to your grandchildren. It could have paid for education or medical bills or home repairs. Instead, it went to lawyers and court administrators. And the emotional cost is even higher. I have sat across the table from too many grieving families who were forced to deal with legal bureaucracy at the worst possible moment in their lives. They didn't need a court date. They needed time to mourn. So why is putting your house in a trust smarter right now than it has been in previous years? There are several reasons, and I want to walk you through each one carefully because this is where the recent changes really matter. First, the probate courts in many states are severely backlogged. The pandemic created delays that the system still has not recovered from. Courts that used to process a probate case in 4 to 6 months are now taking 8 to 12 months or longer. Some counties are scheduling hearings a year out. Your family could be stuck paying maintenance costs, insurance, and property taxes on a house they cannot use or sell for an entire year simply because the court calendar is full. A trust bypasses that entire system. Second, state laws around probate are changing, and not always in ways that benefit families. Several states have increased probate filing fees in recent years to cover budget shortfalls. Other states have added new requirements for executors that make the process more complicated and more expensive. Florida, for example, requires an executor to be represented by an attorney in most probate cases, which means legal fees are mandatory even if the executor is perfectly capable of handling things themselves. California has a statutory fee schedule for probate attorneys that is based on the gross value of the estate. On a $500,000 home, the attorney fee alone would be $13,000 under California law. These are not optional expenses you can avoid once probate starts. Third, property values have risen dramatically across most of the country over the past decade. A house you bought for $80,000 30 years ago might now be worth $400,000. That is wonderful for your net worth. But it also means the cost of probate has increased proportionally because probate fees are typically calculated as a percentage of the estate's value. The more your house is worth, the more your family stands to lose if you have not planned properly. Fourth, and this is something many people completely overlook, a trust provides protection not just when you pass away, but also if you become incapacitated. Imagine you have a stroke and cannot manage your own affairs. If your house is in your personal name, your family would likely need to go to court to get a conservatorship or guardianship just to pay your bills or sell the house to pay for your care. That is another court process with more attorney fees and more delays. If your house is in a trust, your successor trustee can step in immediately and manage the property according to the instructions you already set up. No court involvement needed. No public proceeding where your private medical and financial information becomes a matter of record. Now let me address the most common mistakes I see people make with trusts, because this is where good intentions go wrong. The biggest mistake by far is setting up a trust and then never transferring the house into it. I cannot tell you how many families I have spoken with who found their parents' trust documents in a drawer after they passed away, felt a wave of relief, and then discovered the house was never actually titled in the name of the trust. An unfunded trust is just a stack of paper. It does absolutely nothing. You must physically transfer the deed from your personal name into the name of the trust. This requires filing a new deed with your county recorder's office. It is not complicated, but it must be done. If you skip this step, you have accomplished nothing, and your family will still end up in probate. The second mistake is trying to do it yourself with a cheap online form without understanding what you are creating. Trust law varies by state, and a generic form you download from the internet may not comply with your state's specific requirements. It may not include provisions that protect your interests, it may not properly name successor trustees, or address what happens if a beneficiary dies before you do. I am not saying every situation requires an expensive attorney, but I am saying this is the roof over your family's head, and the largest asset most people own. This is not the place to save a few $100s on a form you don't fully understand. The third mistake is forgetting to update your trust when your life circumstances change. If you get divorced, if your spouse passes away, if you move to a different state, if you have a falling out with one of your children, if you sell the house and buy a new one, you need to review your trust and make sure it still reflects your current wishes and circumstances. A trust that was set up 20 years ago in a different state with a different spouse named as beneficiary is not going to serve your current family well. The fourth mistake is never telling your successor trustee where the trust documents are or what their responsibilities will be. I understand that talking about death and money with your children is uncomfortable, but leaving them completely in the dark and then expecting them to figure everything out while they are grieving is not fair to them. You do not need to share every financial detail, but you should at least tell the person you have named as successor trustee that they have been chosen, where the documents are kept, and who your attorney is. Give them the basic roadmap so they are not starting from zero at the worst moment of their lives. Let me also address a question I get constantly from seniors who are considering a trust. Will putting my house in a trust affect my property taxes? In almost every state, the answer is no. Transferring your primary residence into a revocable living trust does not trigger a property tax reassessment because it is not considered a change in ownership for tax purposes. You are still the beneficial owner. You still live there. The tax assessor treats it as your property. You also retain any homestead exemption or senior property tax freeze you currently enjoy. The trust does not change any of that. Another question I hear often is whether a trust protects your house from nursing home costs or Medicaid recovery. This is a much more complicated topic, and I want to be very careful and accurate here. A standard revocable living trust does not provide asset protection from long-term care costs. Because you retain control over the property and can revoke the trust at any time, Medicaid considers those assets still available to you. If you are concerned about protecting assets from nursing home expenses, you need to speak with an elder law attorney who specializes in Medicaid planning. There are certain types of irrevocable trusts that can provide this protection, but they come with significant trade-offs. You give up control over the assets you place in them, and there is a 5-year look-back period that Medicaid uses to review any transfers you have made. This is not do-it-yourself territory. This requires professional guidance specific to your state's Medicaid rules. Now, I want to walk you through what the process actually looks like if you decide to move forward with putting your house in a trust. This is not meant to be legal advice for your specific situation, but rather a general overview so you understand the steps involved. First, you need to decide what type of trust is appropriate. For most seniors, a revocable living trust makes the most sense. You can change it or cancel it at any time. You remain in complete control while you are alive and mentally competent. The trust becomes irrevocable only after your death or incapacity. Second, you need to work with a qualified estate planning attorney in your state to draft the trust document. The attorney will ask you about your assets, your family situation, and your goals. They will help you name a successor trustee and specify how the house should be distributed after your death. Third, once the trust document is signed and notarized, you need to transfer your house into the trust. This is done by preparing and recording a new deed that transfers the property from your personal name to the name of the trust. Your attorney will handle this, and the filing fee is typically modest. Fourth, you should update your homeowner's insurance policy to reflect that the property is now held in a trust. This is usually a simple phone call to your insurance agent, and it rarely changes your premium. Fifth, you store the original trust document in a safe place and let your successor trustee know where to find it. The cost of setting up a trust varies depending on where you live and the complexity of your situation, but for a straightforward single property trust, most estate planning attorneys charge between $1,500 and $3,000. I understand that is real money, especially on a fixed retirement income, but I want you to weigh that against the alternative. Probate on a modest estate can easily cost your family $5,000 to $10,000 or more, plus months of delay and frustration. When you look at it as an investment in your family's peace of mind, the math becomes much clearer. You are not spending money on a trust. You are saving your family from spending money on probate. There is also something I need to mention that does not get discussed nearly enough on channels like this. A trust is not just about what happens after you are gone. It is about what happens while you are still here but unable to manage things yourself. I have seen situations where a senior had a stroke and their adult children had no legal authority to pay bills, manage the house, or make decisions. The house sat there, the bills went unpaid, the lawn went unmowed. Eventually, the city started issuing code violations, all because there was no legal mechanism for anyone to step in. A properly funded trust with a named successor trustee solves that problem instantly. Your designated person can walk into the bank, show the trust documents, and immediately begin managing your affairs exactly as you instructed. That peace of mind, knowing that you have protected yourself and your family from chaos during an already difficult time, is worth every penny. Before I wrap up, I want to leave you with something practical you can do today. If you already have a trust, check your deed. Go to your county recorder's website or call them and verify that your property is actually titled in the name of your trust. If it is not, make an appointment with your attorney to fix that immediately. If you do not have a trust, start by having a conversation with your spouse or your children about what you want to happen. Then research estate planning attorneys in your area who specialize in trusts. Read their reviews, call 2 or 3 offices, and ask what they charge. get a sense of the cost and the timeline. Even if you are not ready to pull the trigger today, gathering information is free, and it puts you one step closer to protecting your family. The bottom line is this: your house is probably the most valuable asset you own, and it represents decades of hard work, mortgage payments, and memories. You have spent years taking care of it. You fixed the roof when it leaked. You painted the walls. You planted the garden. You made it a home. Do not let all of that care and effort get swallowed up by a legal process that your family never asked for and never deserved. Putting your house in a trust is one of the smartest and most loving things you can do for the people you leave behind. It is not about how much money you have. It is about making a difficult time just a little bit easier for the people you love. If you found this information helpful, please take a moment to like this video so more seniors and families can find this content. And subscribe to the channel for more straightforward explanations of the financial and legal topics that matter most in retirement. I would also love to hear from you in the comments. Have you already set up a trust? Or is this something you have been thinking about but haven't done yet? What questions or concerns do you still have? Let me know, and I will do my best to address them in future videos. Thanks for watching, and I will see you in the next one.